Well, hello, everyone. We're back with an all-star lineup in today's policy forum brought to you by the Competitive Enterprise Institute. We'll be talking about what comes next for one of the most significant, if misunderstood, areas of economic analysis and law, antitrust. Thank you for joining me today. I'm Kent Lassmann, the president at CEI, and throughout the next hour, I'll interject to keep the conversation moving and introduce your questions. Your questions for our panel, including those that come in from policymakers, other scholars, and the lay public. If you'd like to participate, please use the Q&A function found at the bottom of your screen or send me an email at events@cei.org. And as a reminder for everyone, today's event is being recorded and it'll be available later on CEI's website as well as at YouTube. Now, before I turn to my colleague, Jessica Melugin, Director of the Center for Technology and Innovation at CEI, let's take a quick survey of the rest of the panel. In order of their initial comments, I'm delighted to introduce John Tamny, a Vice President at FreedomWorks, Sam Bowman, who's the Director of Competition Policy at the International Center for Law and Economics, and Professor Joshua Wright, the Executive Director of the Global Antitrust Institute. It's no stretch at all to say that the people you'll hear from today are among an elite community of practitioners and experts who policymakers rely upon to understand the interaction of the law, the behavior of oftentimes very large market players, consumer protection, and the current target of ire for politicians the world over, technology and media companies. This is not a new phenomenon. It's been part of antitrust at least since 1913 and the Kingsbury Agreement. We're going to hear about the history as well as looking forward. I want you to help me press them on what it all means right now. So Jessica, you've published a great deal and quite recently on the pressures that have emerged to refashion on a societal level how large technology and media players operate. Why don't you tell us about your research and get us started?
Thanks, Kent. Recently antitrust is certainly, I don't have to tell this audience, it's all the rage. That's true here, that's true abroad. The UK competition watchdog told the Financial Times this week they were gearing up for a big year of new and unique cases. And of course, the EU is always busy. And then back at home, we know the DOJ and the FTC and state attorney generals have their hands full with Google and Facebook. And there's probably more to come on a lot of those fronts and with a lot of other tech companies. But we thought at CI, it's important to kind of look back on the history of antitrust and see how that's gone. So we just did a short survey of some of the big cases that you often hear referenced by supporters of expanding antitrust. And I think when you take a closer look at what those cases really consisted of, there's some lessons that we can keep in mind. So very briefly, I'll go through those. Standard Oil, the case that started it all, obviously occurring before the consumer welfare standard, which has been really important. I know we'll get into that later. But that's such a classic example because at the time of that trial, Standard Oil itself was cutting prices to consumers and increasing output. And I think looking back on it, it's a lot easier to see it as something that was designed to help the failing competitors of Standard Oil, not consumers. And that's important for us going forward when we think about who's really benefiting from these cases. AT&T, a different point there is that people love to point to after AT&T was broken up, didn't everything get so much better? It did, but also important is that AT&T was a government created and maintained monopoly. We have a whole host of government regulatory bodies that grew up around it. And to say that that was something that happened in the marketplace that needed antitrust action is really to sort of miss the forest for the trees there. Moving along and towards technology, the IBM case, great example of what we should worry about in terms of unintended consequences of not just antitrust remedies, but just the threat of antitrust. So what you see in the IBM case is that because the company got worried about its ability for long-term profits, what did it do? It raised its prices for consumers in the short term. Back to the consumer welfare standard there too, but also just saying, the looming threat of antitrust action distorts the incentives in the marketplace And I don't know about you guys, but I'm not sure the nuance of that can be known by many of our illustrious elected officials in Congress these days. So I think that's a cautionary tale. And I'll just conclude very briefly with the Microsoft case. Some of us might be old enough to remember it even. That was just them tying their web browser to their operating system, which now sounds very quaint. And at the time, we were told this is the end of the world for competition. But what ended up happening, and I won't go through all the technological development since that case, but it just illustrates that the market, especially in this industry, often moves much quicker than an antitrust suit by the DOJ can. So we just wanted to highlight that some of these things that are referenced as something to aspire to in going back to the way antitrust used to work might be more of an argument against antitrust actions. So with that, I'm going to stop talking and I'm going to let John say his piece.
Thank you very much, Jessica, and thank you, Kent and Amanda, for making me a part of today's event. Monopoly, it's the goal, I would think. Why else go into business unless your goal is to dominate a market? Please tell me how you'd raise money if your goal wasn't to seriously dominate a market. Furthermore, monopoly is very pro-consumer. If you dominate a market, that's a signal that you've met a need that was previously unmet in the marketplace that no one had discovered or people knew about but dismissed as unnecessary or unwanted. So you hope for monopolies. Furthermore, monopolies are the path to progress, precisely because they generate so much in the way of profits and high valuations. Their success is a magnet for copious investment. Some for imitators who want to chip away at the monopoly's profits, but also for those who think based on what was achieved that they've got an altogether better way to basically knock the dominant company off of its perch. If you don't have monopolies, you're not going to have the investment necessary to improve a specific area, or better yet, remake it altogether. Now, all of this, of course, speaks to what, in my mind, is the matchless stupidity of antitrust law in the first place. Think about it. People only discover monopolies when they're about to not be monopolies, which is really by definition. I mean, if you can predict what's going to be a monopoly, the last thing you do is work in antitrust law or work for the DOJ or anything like that, because you would instead quite literally be the richest person on earth. No one would have more money than you, and that's the case because monopolies get that way precisely because they come out of nowhere, because they discover an all new way to do things that the market before didn't. And so you would own all these companies that were once monopolies. Microsoft, call Amazon today a monopoly if you want to. You would own all of them at the lowest cost basis possible because you would uniquely see what the market didn't. And so it all speaks, I think, broadly to the silliness of conservatives in particular right now, but really both sides. Everyone's up in arms about big tech and, oh, what are we going to do about big tech? I mean, we can state the obvious. We could say, yeah, they used to say this about AOL back in the late 90s, early 2000s. They delayed AOL's merger with Time Warner by a year because they thought that this combination would be impregnable. Within a few years of that merger, Time Warner knocked AOL off of its perch. There's so many examples of that. But the bigger way to look at it, I think, is just to say that if you're focused on big tech right now, that's the surest sign that A, big tech will no longer be that way for too much longer, but it's also the surest sign that you don't see where dominance is coming from because you're focused on the past. We see this all the time. And so it fascinates me that people are saying, well, it's just not fair, Google and Apple and Amazon, they're making it difficult for Parler to compete with Twitter. Well, it's funny because Twitter was in desperate straits not too long ago, but it presumes that we've reached some kind of technological frontier, that the way things are right now are the way things will always be. But what we see throughout history is what antitrust and the ankle biters in it in its enforcement focus on is the past. The most obvious example, but there are endless ones, is Blockbuster. Blockbuster tried to merge with what, Hollywood Video or Movie Gallery, however long ago. It wasn't allowed by the FCC. They would be too dominant in the area of home video rental. Well, so out of nowhere comes Netflix. Blockbuster had a chance twice to purchase Netflix, didn't care to buy it. Well, they came out and wiped them out. And so that's what's got to be thought about today. Big tech, what's going to get it, and it will be gotten. That what's dominant today won't be dominant for too much longer, but rest assured, you don't know what it's going to be, but it's likely not Parler. It's going to be a company that either you've never heard of or has never been founded. And we know that's the case because if you could predict what would eventually dominate, you once again wouldn't be on this call. You'd be the richest person in the world. And so I'll leave it there and hand it back to Jessica.
Thanks, John. That was great. And also, I kind of feel bad about being on this call now, but not really. Okay, Sam, chat with us about what's going on in the rest of the world and all else.
Great. Well, thanks very much. This is my first time speaking at a CEI event, so I'm a kind of long-time listener, first-time caller. So it's a real privilege to be here. Thank you very much, and thanks for tuning in. What I want to talk about are the principles that are underlying what I think are kind of this broad trend in almost every country towards a kind of regulation or a significant change of gear in antitrust enforcement. So I think there are three elements, but I'm only going to talk about one. The first element, which is the one I'm going to focus on, is the idea that digital platforms should be treated as essential facilities, and I'll explain what that is in a minute, with a legal duty to deal with their competitors. The second assumption is that platforms and big incumbents don't innovate, even when they're subject to competition. Only small new entrants do. And the third is that these problems are things that courts and regulators can easily solve without causing unintended consequences and without causing costs. And I think these sort of assumptions underlie the lawsuits against Google, the House Judiciary Report, Congressman Buck's Third Way report, which really I don't think was much of a third way at all, the Digital Markets Act in Europe, the moves that we're seeing in the UK, and in fact the Australian News Code, which was a complete debacle. But that news code really highlighted this first point, this idea that platforms have a duty to deal with all of the companies that are in some way dependent on them because they're platforms. Now, this is basically, I think, a revival of what's called the essential facilities doctrine. But historically, this has been applied to things that were considered to be natural monopolies. Now, they may or may not, in fact, be natural monopolies, but the idea was if you have something like, say, a harbor, an electricity grid, something where it's really difficult for you, once one has been built, for a second to come into the market and compete with it. The treatment of these has been as a kind of, jointly owned piece of infrastructure with rules and price regulations to decide on what terms other businesses can use this. But when we apply this to digital platforms, when, of course, there are lots of digital platforms, I think there's quite a lot of competition in digital markets. What we're saying is that simply by virtue of being successful and simply by virtue of having a large customer base, you have become effectively an essential facility. And secondly, what we say is essential facilities, so-called, these digital platforms, should all look in a particular way. They should all be as open as possible, and they should all be as neutral as possible. I think that's mistaken because when we look at markets, we see that customers do not prefer the most neutral platform, the most open platform. When you look at retail, for example, they have options like eBay, which is very open and very neutral, although not completely open and not completely neutral. Amazon, which is sort of open and sort of neutral. Amazon sells its own products on its platform, but third-party sellers can sell their own things as well. Or, in a way, Walmart is a little bit like a platform because third parties have to interact with Walmart and they do business with Walmart, and then Walmart acts as an intermediary that allows you to buy things like Heinz ketchup and so on. All of these have different levels of self-preferencing, different levels of behavior where they say our own products and our own services are going to get a special leg up in this offering, and different levels of openness where they say, you know what, if you are found to be selling again and again goods that just fail after a few weeks on this website, you're not allowed. When it comes to Amazon, they're fairly strict about that. When it comes to eBay, provided you're not committing fraud, they're not so strict. So the point of all this is that there is no a priori level of openness. There's no objective point where we want all platforms to reach and where we think that there should be a regulator that can say, without looking at the specifics or even having looked at the specifics, can say, this isn't open enough. There is no substitute for basically what consumers themselves tell us, which is the things that they choose to go to. And we can see this when we look at things like when we look at computer operating systems. Windows is a much, much more open and a much more neutral platform than iOS, the operating system you have on an iPad or an iPhone. Being open means that it's much easier for a developer to have a third party, a consumer, install their app on it. But on the other hand, for consumers, there's much less reliability in terms of what works. It's much more likely that you'll get infected with a virus. It's much buggier, it's much less secure. iOS, on the other hand, I think probably because of the Windows experience, is designed to be closed, and it's designed to be very, very, very difficult for third parties to get their software onto unless they have really followed all of Apple's rules. Now, that's actually really, really good for some developers, because if you're a no-name Lithuanian developer who nobody in the rest of the world would even have heard of or would feel safe doing business with in kind of normal channels, Apple acts as an intermediary. It provides trust, it provides security, stability, and so on. So it's really good for those developers. But when developers themselves develop a reputation, and when developers themselves become kind of confident and have enough sort of confidence from their consumers, that intermediary role performed by Apple becomes a lot less valuable to you. So this is why we see companies like Epic Games, Spotify, that have this kind of resonance with consumers and have consumer confidence, saying that we don't like this system anymore. It's really unfair that this system isn't neutral and isn't open to us to use in the way that we want to. But it's not clear at all that this is true overall. This is just the true for these particular companies. And since consumers can switch away from Apple products, it is in fact possible to use an Android. It is in fact possible to switch. I've switched back and forth in the last few years. The constraint on what Apple is able to do is always there. If Apple decides to squeeze these businesses so much that they no longer want to perform and they no longer want to produce services for users of Apple's products, people will switch away to a more open system, and there'll be an opening in the market for those more open systems. I've talked a lot. A final point is that when we look at lots of platforms, interestingly, it's often the openness that they have that makes that are consumers' biggest objections and consumers' biggest kind of complaints. When you look at Apple, when you look at Amazon, one of the biggest complaints consumers have is to do with third-party merchants selling goods that are counterfeit, fake reviews, dodgy return processes compared to doing it through Amazon. But there's a balance, because it also increases the availability of different goods. It also increases the range, the service, the size of Amazon's platform, and ultimately the value of Amazon's platform. But what Amazon's job is to find the right balance between openness and closedness and neutrality and non-neutrality. And it's really difficult to do that. And it's thanks to competition between Amazon and other would-be Amazons, like, for example, Jet.com, which is now Walmart's attempt to build an Amazon competitor, which is where my brother works. So I'm very enthusiastic to always big up this competitor. These companies are always nipping at the heels of these digital platforms, and they're always looking for the chink in the armor and the chink in the decision-making that has taken place in these digital platforms. So when we treat them as essential facilities and we treat them as things like electricity grids or harbors or railways that can never be removed, we're giving up on competition. And we're saying no longer can competition take place. Instead, we're going to have to settle for what we've got. And the best thing we can do is just regulate these things. I think that's mistaken. I think competition is taking place in these markets. And I think it's misguided, because the sort of regulation we'll get will push them all in a particular direction, which isn't the one that consumers want, and which often is the one that will be actively detrimental to consumers and I think innovation as well. Thank you.
Okay, so Sam has told us a little bit about how consumers benefit when there's not a top-down, one-size-fits-all approach to this. And I'm hoping Josh will tell us about the consumer welfare standard as a legal concept, how it's been helpful and what attacks it's currently under.
Sure. And first, thanks for having me. It's a pleasure to be here, and always fun to get to talk antitrust. So I think it is a helpful thing to contextualize the current attacks coming from both sides, left and right, and in the courts. In antitrust, we've got, the agencies either have lawsuits or open investigations against every tech firm that's been named during our first 20 minutes here. And you've got proposed legislation in the House. In the Senate, Sam mentioned this House report. It's this monstrous document. It is quite ambitious. It proposes overturning every Supreme Court case in antitrust since 1977. It proposes overturning a law review article. I don't know what it means to overturn a law review article, but it proposes to do so in a footnote. I'm mostly jealous that no one's proposed to overturn one of my law review articles, but I'm working on it one day. So you've got this sort of big, broad, sweeping proposals to ditch modern antitrust in favor of something else. And the something else is usually described as something shiny and new. And the history says something else. So I want to talk about that a little bit. I will do the Cliff Notes version of the history. But if you read all of the antitrust cases from 1890 to 1977, and I did, so you don't have to, they would say something like everything's illegal. All the things. If the thing you're thinking of right now is definitely illegal and probably a felony under the antitrust laws as interpreted from 1890 to 1977. One of the reasons for this is Congress wrote these sort of really vague statutes. Thou shalt not now enter into restraints of trade. Don't monopolize. The Clayton Act came later. Mergers that substantially lessen competition, but sort of wrote a blank check to the courts to figure out what that meant. 1890 to 1977, the courts struggle with this, and they've got antitrust law out trying to maximize 8 things at once. It might be about consumer welfare. It might be about protecting small business, maybe particular industries, maybe about saving competitors, maybe about climate change. Could be anything, right? And antitrust was a tool for whatever. And unsurprisingly, it was used to achieve all sorts of different socio-political goals and in a manner that's inconsistent. Virtually everyone, left, right, and center, who looked at the body of antitrust law, sort of 1890 to 1977, and particularly sort of low point in the 40s, 50s, and 60s, looked and said, none of this makes any sense. Bork most famously in the antitrust paradox, but there was widespread view that antitrust simply didn't know what it was doing. When you try to maximize 6 goals at once, usually you mess one of them up. Antitrust did. And so if you read those decisions, you see lots of things that look sort of plainly anti-competitive on their face, given the blessing of the Supreme Court. Jessica, you started with some of the sort of Hall of Shame antitrust cases. Among my favorites in the 60s, if you read the merger cases, there's a dissent in Vaughn's Grocery. It was a grocery, and it's not big tech, but it's a supermarket grocery merger to about 4 or 5% of the market in the early 60s. And the government wins. They always did. And Justice Potter Stewart in dissent says, in fact, the only thing that's consistent about Section 7 Clayton Act cases is the government always wins. What are we doing? The evidence on the record was the merger was going to make prices go down. People were going to get more food cheaper. And the Supreme Court declares the merger illegal. Most of the pushback against the old antitrust cases coming from all sides looked at those cases and said, whatever we're trying to do with this antitrust project, we're not doing it well. Supreme Court comes in the 70s, a bunch of unanimous decisions. These are Scalia and RBG in the same opinions, right? A bunch of 9-0 and otherwise supermajority cases where the Supreme Court says, new rule, we're going to make antitrust a consumer welfare statute. All we're going to do is we're going to try to maximize one thing, right? We're just going to do consumer welfare. And your mileage may vary on how well the courts carry out that function or how well the agencies carry out that function when they get to court. But this was a massive intellectual and analytical save for antitrust to move from sort of 6 goals to 1 and to adopt the consumer welfare standard. What this means is when plaintiffs, the FTC wants to sue Facebook and the DOJ will sue Google. If they want to win those cases, they need to walk into an Article 3 court and put their money where their mouth is. They need to walk into an Article 3 court and show that the practice alleged to violate the antitrust law harm consumers. Like most areas of law, we can debate around the margins. The courts make mistakes in some of these cases, right? But no longer can agencies simply sort of wave their hands and say, even if this conduct is pro-competitive, we are going to declare it unlawful because the law allows us to do that. The consumer welfare standard focused antitrust laws on the actual impact of the practices, on economic analysis as evidence to show that the practice at issue either helped or harmed consumers. And it did one other thing, and Sam's comments got at this a little bit. The other distinguishing factor or distinguishing characteristic of American antitrust law is the idea that sort of, if I can piggyback on John and Sam simultaneously, that monopoly power isn't unlawful in the United States. And it's for precisely the reasons that John laid out. Our system says, if you build a better mousetrap and you get to charge the monopoly price because of it, that's not just something we tolerate, that's something that we celebrate in American antitrust law. That's unique. There are 130 something antitrust laws around the world, and the United States approach to allowing you to compete to create monopoly power is relatively unique, and the antithesis of this sort of duty to deal essential facilities move we see in the modern discussion. So fast forward to now, and the sort of buzz around doing something new in antitrust. Most of the proposals look a lot like bringing antitrust back to its state in the 40s, 50s, and 60s. Abandon the consumer welfare standard, give huge swaths of discretion to the agencies to declare conduct illegal, whether or not they can prove it harmed consumers in court. One of the most, in my view, outrageous proposals is to shift the burden of proof in merger cases. That is, guilty until proven innocent when it comes to voluntary mergers and acquisitions between firms. That's the I put forward as the compromise position. That's the third way. I'm with Sam. It's sort of neither third nor a way, but these are sort of the aggressive nature of the proposals that are out there. I think they are mostly, if not entirely, short-sighted. We are, 50 years from Justice Potter Stewart's dissent, where he said the government always wins. Fast forward to 2021, the government wins about 85% of its merger cases. It ain't 100, but it's pretty good work if you can get it in terms of an agency's win-loss record. It is difficult to look at the modern antitrust record, what the agencies are able to do in court when they sue, the powers already vested within the agencies, and think that there's any sort of crisis that needs legislative attention, at least in the direction of more power, not less. Instead, what we get are a bunch of proposals that would do away with what I think is really the only safeguard the American antitrust system has, which is the courts. Right? The agencies still need to go to an Article 3 judge and win if they've got a claim that particular conduct, whether big tech or otherwise, violates the antitrust laws. Critics of the modern antitrust system, be they left or right in their political views, see that discipline of the courts as a problem and are proposing legislation to circumvent it. What this does is it gives us situations like we see in Australia with the Facebook ACCC sort of news media kerfuffle. Instead of big tech companies and other companies, frankly, spending their time, energy, and attention competing for consumers, they compete for the attention of their favorite regulator, right? We invite, when we give greater power and discretion to the regulators and do away with Article 3 courts as a safeguard, we invite firms to compete and compete intensely. But instead of competing for our dollars, they are now told the biggest rate of return is to compete in a rent-seeking contest with your neighborhood regulator. That is not good for consumers, and it is not good for competition. And I fear that that's where many of the proposals to modify sort of modern antitrust are going, sort of back to the doomsday of antitrust of the 40s, 50s, and 60s. I've talked a lot now too, so I will stop there.
Josh, I was just about to interject because I don't mean to step on you, but you were closing there with some insights about public choice. And the very first comment we received from the audience comes from a stalwart of public choice and industrial organization, someone who was present at that major pivotal moment when we shifted in the early 1980s. The FTC under Jim Miller included an economist by the name of William Shugart. And he writes, I hate the phrase unintended consequences. As George Stigler once wrote, the actual effects of regulation, including antitrust, are the intended effects. Now, Bill's point is not a question unless someone on the panel disagrees, but I do want to ask, are we getting what we deserve because of the nature of these open-ended statutes that have enough room for different political folks to seek their control over the market as opposed to letting the market emerge and develop on its own?
So I'll give you, it's great to see the professor in the comments. I'll give you my thoughts on that. And, you know, I'll offer sort of two different perspectives. The first, the one that I take is there's no doubt that the bills that Congress passed in 1890 and 1914 and the antitrust laws, you know, you get what you pay for. And what the courts did was, what Congress did is say, hey, courts, figure this out, right? And the courts did sort of exactly what I described. I think antitrust was, you know, speaking of the intent of 1,000 court decisions is a metaphysical exercise, and I'm not going to engage in it. But we got a mess, that's for sure. I think the story of the adoption of the consumer welfare standard by the Supreme Court is one of the greatest successes of sort of it's a statute, but I'm going to use loosely the phrase common law legal tradition anywhere, right? We had antitrust go from the 60s where everything was illegal to adopting the consumer welfare standard and to some extent giving antitrust sort of a rationalized direction. Better than it was. Not sure if there's you know, I've been a vocal critic of lots of applications of modern antitrust, but to compare it from the 60s to the sort of post-consumer welfare standard, you know, no contest. What you have in the modern application of antitrust law in the courts is a relatively stable set of doctrine, some of it misguided, but stable. You can counsel businesses around it. One of the reasons you're seeing legislative attention is precisely for that reason. It is not easy. If I were a betting man, I'd bet the DOJ is going to lose its Google case and the FTC is going to lose its Facebook case. And the reason why is the courts now say, if you want to win those cases, you can't just wave your hands wildly. You've got to come in and show evidence of market failure and convince an Article 3 judge and maybe a 3-judge panel after that, and maybe the Supreme Court after that. Good luck to you. That usually doesn't work out for plaintiffs in modern antitrust cases. And that's cold comfort to the firm that spends, you know, millions of dollars defending itself. And, you know, we get, you know, we deter innovation and competition, and there are real losses from that. And I don't want to minimize them, but I think there's a reason why the action's happening in Congress, not the courts. It's because most of these parties know they're going to lose in the courts. And that, for better or worse, says something about the improvements the courts have made to antitrust and the problem that Congress put on their doorstep in 1890.
I want to talk a little bit about, because we've mentioned Congress being sort of where the action is on this. And I know John's written a little bit about people from the right who we might expect in Congress to be operating under some larger principles, whatever they may be, and have some instincts against expanding antitrust, and how that's not happening right now. I think, John, if you're like me, you sort of expect a lot of this from the left because they just genuinely love regulation. Like, they just think it works and it's great, and that's sort of the Band-Aid for every ailment. But talk a little bit about, like, from the right, where do you think what's happening with this? It's not all of the right, but it's a streak in the right, and the short-sightedness maybe politically that's happening, but also I'm not surprised by that, but I find it interesting, the short sighted, like Sam was talking about. You have to kind of let the market respond, right? A company makes a choice, that's an opportunity for another company to come in and make a different choice. I think there's a short-sightedness with letting these economic frontiers sort themselves out, and I kind of expect that perspective to be a little bit more of a knee-jerk reaction from some on the right. But what do you think about how some on the right in Congress have approached this?
Yeah, to be clear, they sound like Democrats. Suddenly big business is bad to Republicans. You see what Amazon did. It's owned by a liberal, and he and Jeff Bezos made it impossible for Parler to operate. So that's bad. And it's so short-sighted because it presumes once again that the cloud, that AWS, that Google is somehow the frontier. But we know from history, gosh, go back to 2006, the view was that social media was going to be defined forever by MySpace. In 2006, MySpace had as many daily visitors as Google's. Well, how did that work out? Implicit here from Republicans is that we've got to go after big tech now, because what they're doing will strangle any future arrivals into the space, so that conservatives get their voice and everything. And it's just so important for them to have their voice. Well, please. Implicit there is that where we are today is frozen in place, and that we'll never move beyond that. But what we know throughout history is that giants always stumble. Let's not forget that Microsoft, as you point out, is this quaint notion that it was attaching its browser to its software. That is so yesterday. Microsoft was late on search. It was late on social media. It was late on smartphones. Giants stumble. Let's go back. Does anyone... or do we have any sports fans here? Why did ABC get Monday Night Football? It got it because the two big networks at the time, NBC and CBS, had zero interest in it. They thought no one would watch pro football on a Monday night, and so it was an entryway for ABC. Interesting there is that Anheuser-Busch was the dominant advertiser, a beer company at the time, but it turned down this laughable notion of pro football on Monday night. So it's an opportunity for Miller to come in and greatly expand its market share. Notable about Monday Night Football is that eventually O.J. Simpson was on the telecast. O.J. Simpson ultimately became a movie star, and they actually wanted him for Terminator. The problem was that the suit said there's no way anyone would believe that O.J. Simpson, someone as nice as him, could ever murder someone, so they chose Arnold Schwarzenegger instead. What we see throughout history is that future is very opaque, and precisely because it is, we know that what we're looking at right now will not shape the future. Someone will come in. If we knew it, we'd all be billionaires. And erase this present and make the present look primitive by comparison. So stop worrying about it. Gosh, Republicans and conservatives have become such victims in modern times, and it's embarrassing.
I think we can officially declare this event a success because we have been able to work O.J. Simpson into it. I'm going to say it. I stand by that. I can defend that later in the comments. But I do want to talk, Sam, a little bit about, I feel like those of us who are concerned here are very focused on defending and saving the consumer welfare standard. But, you're looking at a continent and a country separate now, congratulations on that, where that's not paramount like it has been to U.S. antitrust law. And I'm interested in your perspective looking at it across the pond, how that impacts when you look at these cases. A lot of the same arguments we can make, especially at CI, where we just don't like antitrust at all. We agree it's a lot better with the consumer welfare standard, but we could just leave the whole thing. But wondering, when you look at these cases, where does that sort of thinking overlap and spill over into just the practical realities of antitrust enforcement?
Well, in the spirit of the paper that kind of launched this discussion, I think the Google Shopping case in particular really sets the scene for a lot of what we're looking at. A lot of the reports and attempts to change antitrust that I've mentioned build on the kind of model of the shopping case, which basically says that Google is at fault for changing the design of its search results page and for changing its algorithm, because that disfavors or hurts these price comparison websites that were basically the competitors of Google Shopping, and that Google is required to kind of work with them, give them, as it turns out, give them places in the Google Shopping carousel. And the underlying philosophy there goes right to what Josh talked about. It's to say that the welfare of consumers is not important, and consumer welfare is really almost nowhere to be seen in the Google Shopping case. What matters is the welfare of the competitors of Google. So, I mean, Josh mentioned this point that, if you build a really great mousetrap, it's fine to charge monopoly prices. The implication of the Google Shopping case and the implication of all of the reports we're talking about is that if you design a product that is complementary to that mousetrap, so if you make a really, really nice kind of cheese that mice really love, but that only works with that mousetrap, the mousetrap inventor and the mousetrap company has a legal obligation to you, the cheesemaker, not to its customers, but you, the cheesemaker, not to change its product in a way that might hurt you. So they can't bundle cheese in with the product. They can't change the design so that the delicious smell doesn't waft out anymore. And the problem with this is you can pretty clearly see how quickly that constrains innovation and that constrains product change. And unless you focus on the well-being of consumers in cases like this, you are basically paralyzed, because almost all pro-competitive moves that companies make are in some way harmful to their competitors. I mean, a price cut is harmful to competitors. We don't condemn a price cut usually as being anti-competitive, because price cuts are good for consumers, and we say it's fine for that to hurt competitors. Their response should be to either leave the market or cut their own prices. Once you take that final question as to how does this affect consumers out of the equation, you're totally paralyzed. And I think to some extent, I don't want to overemphasize how paralyzed we are, because I think that the natural implication then is, well, we have to regulate the behavior in some way, either judicially or through explicit regulation, as is now becoming the case in Europe. You can see that in the Digital Markets Act, which is being brought forward by the European Commission, which sets out explicit lists of do's and don'ts for digital platforms, and says, you may not use user data gathered in this way to design products in certain ways that your competitors don't have access to. You may not change your algorithms in ways that basically break the complementary product that a competitor has designed. This is really getting into a point where, what is the room for innovation in these areas? And in particular, when these kinds of rules constrain platforms moving into new markets, we're saying almost the main form of competition that takes place in platform markets is prohibited. So I think it's really kind of the natural conclusion of not letting consumers be the final arbiter of what's allowed in markets. And sadly, it's not just constrained to Europe anymore.
Yeah, I think there's a lot of overlap, and I'm seeing that our Q&A is filling up, so I'm going to guess Kent's going to want to go to that. But I want to tell you one thing about the search results. It's a joke stolen from my colleague, Clyde Wayne Cruz, who has made a meme and sends it around every time this comes up, and it says, Google case, all search results must appear first. And that's sort of the logical implication of saying, oh, they're favoring their own stuff. It's like, well, what do you want them to favor, right? You have to favor something, and we're very confident that what they should be favoring is what they think consumers would favor, right? That's the correct incentive. So, okay, with that, I'm going to let Kent start plowing through the questions here if he wants, because we're.
Yeah, I'm going to try to wrap a couple themes together that are popping up in the question lineup, and maybe turn to Josh first about things that we've heard from both John and Sam. Because you've had practical experience as a regulator in this field, and the questions about new technologies and new innovation and new developments in the market by the time these cases get in front of a regulator or a court, how are those things dealt with? How do you deal with rapidly changing markets when you're an actual practitioner and you only have the facts in front of you, the facts that are presented?
Yeah, so let me say a couple of things. The stylized set of facts that are the cases the regulators want to bring in this area, and I'll give you an example of how these, what these actually look like. But the stylized set of facts are, you've got a product market and you've got, firm A buys firm B, and firm B's got a technology that would be a competitive force. Firm A buys it and buries the technology, and it never sees the light of day, and consumers are deprived the benefit of the competition. You actually see some of those in pharma from time to time, what they call killer acquisitions, right? You buy the would-be competitive product before it ever sees the market, and you bury the thing. There's those exist. Those are there's a handful of those cases. What the regulators have tried to do is try to identify that stylized fact pattern and generalize it to cases involving all sorts of competition. And that's, I think, where you've seen a problem, right? So one of the things in Ken Buck's report is trying to change the law for cases that involve mergers where the acquired firms got some nascent technology or something. How do we know that? I don't know. The regulator tells us or something, right? This is, difficult in practice, but the stylized set of facts they're trying to get at are those. My favorite case when I was FTC commissioner, by which I mean my favorite case to dissent, which is what I spent most of my time doing, was the merger of Nielsen and Arbitron. So we have people listening will know who Nielsen and Arbitron are, but they are the companies you think, right? They track in your TV and your radio to do ratings, right? And then they sell that product to advertisers, so that they can accurately track and measure and price stuff, right? They do some other things, but those were the products at issue in the merger. So it turns out the holy grail in both of those fields are what they call, I'll mess up the term now, but it's sort of multi-screen syndicated counting, right? So that if I'm watching something on my TV and I move to my smartphone, which you can't see because I've got a virtual background, but I'm waving it around, I promise. And then I move to my laptop to watch something so that you don't double count, right? They want that to all count as one watch. So both of these guys are trying to come up with technologies that will allow you to do that across devices, across screens. They've never done it, right? This merger was back 2013, 2014. They had never done it, but the FTC was worried that they were both trying, and if they merged, one of the efforts would die. The complaint, you can look this thing up, the complaint alleges a market in which no dollars had ever been transacted on the planet. It's not a market at all, right? The product didn't exist. Neither company had made it. One of them had given up on making it. So there's no limiting principle, right? This is beyond going into the, Bill Gates as a teenager in the garage to make sure nobody buys the tech then, right? This is a product that did not exist. And the FTC was suing on the grounds that a merger would create harm in the product market for a product that didn't even exist. I jumped up and down. I told you already it's a dissent, so I got outvoted. That's the line of cases that makes me worry about this in practice. Now, those parties had practical reasons to sign a consent, right? They gave away, the technology for that business to some third party and they merged anyway. The good news here is these are sometimes what we call potential competition cases. Government has a hard time with them in court. Right? The other one that they brought when I was at the FTC is Synergy, which was gamma radiation sterilization technology. They lost that one in court. And the court said, all you've done is wave your hands around and say that you think that this other firm was going to come to the market, and you think if it did that, it would compete and be effective. And you didn't show me proof, you lose. So the handful of cases where the FTC, I gave you that big sort of nice win rate. The handful that they tend to lose tend to be these sort of more speculative claims probably as it should be. But the trends, both in legislation and in agency activity, are to get more and more adventurous about claims that mergers affect future innovation in some way that we can't see, touch, taste, smell, or hear, but the regulator is sure they know and sure that they can convince a court.
I'm going to try a quick round of speed round. And after 2 or 3 quick questions where you got 12 seconds each, we're going to do wrap up, because these topics could go on forever and we are limited by 1 hour. So let me ask, Sam, you talked a little bit about the comparative political economy of the EU and the American systems. What's the greater threat right now in America to consumer welfare? Is it the state attorneys general, or is it federal regulators at either the DOJ or FTC?
Well, I think, to answer your question, it's federal regulators at the DOJ or the FTC, but I think it's most Congress. I don't, like Josh, I don't think that the state AG cases are very good, and I don't think that they have a very, very high chance of success. Yeah, that's as short as I can do.
Speed round. John, let's piggyback on that. What is the probability between 0 and 1 that this Congress, the 117th Congress, will pass fundamental reform of our antitrust laws?
Oh, it's next to nothing, because there's no incentive to pass it. If we actually had good antitrust laws, Congress wouldn't have a purpose or call to raison d'etre. So expect this to always be politicians exist to be sucked up to, and antitrust law ensures just that.
Public choice at work from John Tamny. Josh, let me ask you real quick. What do you make of the proposal from Harvard's Michael Porter about shifting from consumer welfare to a productivity growth standard?
I don't like it. The reason I don't like it is because it is more amorphous. You can get economists in a room to understand what that means. You give it to a regulator, it's worse than consumer welfare. And it gives the agencies more discretion, not less. And I'm in the less discretion camp.
Jessica, since you spend most of your time with me, I'm going to give you the last word. And I'm going to ask each of our guests here to share with us closing remarks and maybe 1 or 2 takeaways that they want our audience to have as they watch these stories and they watch these cases make their way across the front pages. So we'll go with John, Sam, and Josh before I turn to you, Jessica, to help me wrap up. John, what's your takeaway for the day?
Oh, my takeaway is just always consider the unseen. If we did not have this, let's consider Amazon, one of the richest companies in the world. Why did Jeff Bezos buy the Washington Post? It was the best purchase he ever made. And why was it? It bought him protection from antitrust. It bought him protection from these people coming after him as he grew. But what a waste of his time and money. And so the unseen with this is always fascinating to consider what companies could do, how much better the economy would be if there weren't rules against greatness.
Sam, how about you?
What I would say to conservatives who are nervous about what they see as a restriction of conservative speech on digital platforms is that when this is alleged to be happening, the allegation is that platforms are not acting in a profit-seeking way. If that is true, then the goal should be to incentivize platforms to act in a profit-seeking way as much as possible, because the alternative is to give powers to some kind of regulator that you would not want under any circumstances to be held by your enemy. So the choice is focus on competition and focus on profit-seeking behavior by digital platforms, or try to regulate them and give the tools over speech to potentially your worst enemies.
Now, I'm going to break my own rule here. I just told you guys what I was doing with the last 5 or so minutes. Jessica, do you have a word to add? I know you've done a lot of research on a topic that Sam introduced here right at the end about speech and publishing. Anything you want to add before we go to Josh on his concluding remarks?
Yeah, I think there's a weird overlap there, and that is that a lot of the action from the right seems to be just worried that there's not a little lack of faith in the process here. And I would, like we talk about at CEI, regulation that includes antitrust, that would include content moderation regulation. It's the greatest harm it does is it prevents the market response that would have happened anyway. And I think that's a little bit what Sam's getting at too. Let's see what the next generation of social media looks like. I think that we talk a little bit about at work how it might be a very decentralized sort of Napster model for things where there aren't the bottlenecks to deplatform people. That might look, and again, to John's point, if I knew that, I would be investing in that technology and not here. But the point is that I do believe that, and this is an argument against the essential facilities in both antitrust and social media, the market will find the best answer. The market will have an answer. I don't know, I can't tell you what that answer is, and that's what makes it hard. But I think that especially people on the right need to remember that the market solves these questions quicker and more the most people's liking than government regulation is going to do. And I think in that way, there is overlap between the social media content moderation questions and antitrust. I just trust some entrepreneur who maybe hasn't even thought of the idea yet more than I trust a Congress whose average age is, I don't know exactly, but too old to be in charge of the future of technology.
All right, Josh, I'm putting you in cleanup position. We've got a lot on the table here. History, forward-looking innovation, comparative political economy with different regulatory structures, consumer welfare standard, Michael Porter making a late entry into our conversation. There's just a whole lot here. As you survey the field, what is the most important thing for people to understand going forward into these debates?
I think the fundamental choice about the design of American antitrust law is whether we are going to continue to have a unique system, unique here, because both the coupling of the consumer welfare standard and the rule articulated by Justice Scalia in the Trinco decision, that we reward monopoly and the ability to set monopoly prices through monopoly earned through innovation. That is a truly unique feature of American antitrust law. And if you look at where the innovative companies are and where the growth comes from, it's a whole host of reasons why it's here. But that the antitrust environment compared to the rest of the world certainly is one. And we are in danger of tinkering our way out of that by adopting a regulatory model instead of the imperfect one that we've got. Jessica said lack of faith in the process, and I want to steal that for a second. The other sort of irony with conservatives is we've spent all of this time and energy and blood, sweat, and tears on judges. But what about the judges, right? We filled up the Article 3 courts with all of these judges. And the second you get a little bit of heartburn about a tech company, it's take the power away from the Article 3 judges and let's empower the Democratic FTC to decide everything. It is nonsensical on its face, but I think that's the choice that we've got, is whether we are going to have a regulatory-centric antitrust system with no judicial review and superpowered regulators, or one where the courts play a meaningful role as a backstop and we keep the consumer welfare standard as is. That's, I think, where the rubber hits the road. I've got my money on the consumer welfare standard winning out, but it's a fight worth watching.
All right, very good. I want to say thank you to each of our guests. A reminder that at our website at CEI.org, there's a section of the page devoted just to these issues that not only features all of our own work going back decades on antitrust policy, but pointers to friends and allies and people who have interesting ideas on this. I encourage you to check out the organizations where Sam and Josh and John are all doing very good work. Is a very rich vein of analysis right now in the moment about antitrust law. As we wrap up, the screen in front of you will naturally come to a survey. I promise you that survey is less than 90 seconds. I believe we have 4 questions for you. All of those survey results are read and paid attention to. They help us form better programs and better information for you in the future. I would appreciate it if you'd take a moment to fill that out. And I want to note for everyone that 2 PSAs here. First, John Tamny has a book coming out next month, so look for that, When Politicians Panicked. I can't tell you more because for some reason I got off of John's advanced copy list, so we'll have to beat him about the head and shoulders and see if I can get a copy of the book soon. Secondly, we have 3 upcoming events here at CEI that I want to put on your radar. Look for notices in your email so that you can register for those events. Next Tuesday, we'll be doing a book forum with Steve Sukup. We'll be interviewing him about his new work, The Dictatorship of Woke Capital. On Wednesday, the 17th, we'll be releasing CEI's agenda for Congress. The event will feature Senator Rand Paul. And on the 25th, we'll have another book forum featuring the latest from Johan Norberg, Open, The Story of Human Progress, and he'll be complemented by Patrick Moore, who's written about fake invisible catastrophes and the threats of doom. All of that and more is available. It's in the works, and it's coming to you soon. Thank you for joining us today and being part of what we do here at CEI. With that, our program's over.